Good morning. May it please the court. My name is Jill Clark, and I am the attorney for petitioners, who include Gregory Wursel, who's here in the gallery, Heather Robbins, the voter who's here in the gallery, and of course myself. If this court accepts petitioners' view that we must elect a successor to the departing Kathleen Blatz, then no discovery would be necessary. Petitioners read, as a general matter, Article 6, Section 8 of the Minnesota Constitution in conjunction with Article 7. And if we would have a criticism of some of the prior rulings of this court, it would be that there appears to be a tendency to read Section 8 in isolation. But we're not sure that the court needs to reach that issue in this case, because it is our position that the prior precedents that were pointed to by the respondents, such as Dieter versus Carlson, and if you look at the Amdahl decision, that those are not this case. That is to say, the facts in this case are not just about one resignation and one appointment. The facts in this case are about a resignation and an appointment and a resignation and an appointment. We do criticize the systemic overuse of appointment, but we don't believe the court even needs to reach that. If it agrees with our proposition that under the language of Article 6, Section 8, as interpreted by Clark versus Pawlenty, otherwise known as Clark 1, that we have to look at who resigned and who is the successor, who is the person succeeding. We believe that when all of the decisions are looked at together, along with the language of Article 6, Sections 7 and 8, that the conclusion is clear, that at a minimum, by 2008, the voters in Minnesota were entitled to elect a Chief Justice to replace Kathleen Blatz. That election should have happened in 2008. We believe.
What do you base that on?
We base that on our reading of Section 8 as enhanced by Clark versus Pawlenty's definition. And I can point to a portion of our brief. In Clark versus Pawlenty, the issues were somewhat different. I mean, there was this overriding core of whether or not there was a systemic overuse of the appointment process, but in particular, we were scouring Section 8 in that case to determine whether or not Lori Gilday, who had been appointed to seat number 4, could succeed herself. And it was the position of petitioners at that time that she could not. The court, however, and this is at page 5 of our reply brief, the court in Clark versus Pawlenty stated, it seems equally plausible as a third alternative to this notion of the definition of a successor that the phrase, quote, until a successor is elected and qualified means the successor to the judge whose departure created the vacancy in the first place.
Well, the court indicated that it was equally plausible. Did the court make that its holding?
Our position is that if you read Clark versus Pawlenty as a whole, that it did that that's the interpretation that it took, that is how it came to the conclusion that Lori Gilday could run to succeed because she was succeeding the departing judge, the departing justice. So we would argue.
Ms. Clark, respondents argue that Section 8 is not ambiguous and that it has a clear meaning. From what you seem to be saying, I infer that you're saying that it is ambiguous, or are you arguing that you agree that it has a clear meaning, you just disagree on what that clear meaning is?
I hope this answers your question, but please let me know if it does not. We believe the meaning is clear, that the power to elect resides in the people. That is our reading of Section 8. I don't know that you can parse it as it must be parsed in some of these cases without defining successor. In other words, who is succeeding whom? And I think that is where we part ways here, that petitioners are arguing that the shall elect language is paramount. When you look at Article 1, Section 1, when you look at Article 6, Section 7, that the shall elect is paramount. Everything falls behind that. We believe that that is the mandatory language, plain reading, not ambiguous. But then when you look at the final sentence of Section 8, the successor shall be elected for a 6-year term. How is this court?
Doesn't that raise the question as to who or how successor is defined?
It does. We would agree with that. And that's why we pointed to Clark versus Pawlenty, because at least our reading of that case is that given several options of how to read it, that court said the successor is succeeding the judge who departed in the first place. And we would argue that the section must be read that way, because otherwise you would see what, with all due respect, we see now, which is the over-appointment, over-resignation, over-appointment systemically, to the point that we now have in this case.
Counsel, in Enger versus Holm, the court said that successor means the successor whose election is made necessary by the vacancy. It seems that the Clark language is just picking that up. They said in the first place, but there was just one vacancy. So how do we apply that to this case, which you pointed out is different because we have successive vacancies?
Yes, exactly. Thank you. And we would say that a lot of the prior precedent don't help or hurt petitioner's argument here because, as you point out, there was only one resignation and one appointment. We believe that this notion of, the language that you just read would apply to departing Justice Kathleen Blatz. That is our argument. And what we don't see printed in the plain language of Section 8 is this notion that there can be successive resignations and successive appointments such that there is no election. There has not been an election for the Chief Justice seat since the year 2000. We do not anywhere in Section 8 see language that would allow successor to be read to mean the person appointed after the person who was appointed after the person who was appointed.
What do we do with the language that says whenever there is a vacancy?
If the court believes it needs to reach that, our position on that is that a vacancy in this situation would apply only till the till the successor is elected and qualified in January 2011. In other words, if there was any need to fill the gap, as has been discussed in certain cases, in the Zettler case, for example, if there was a need to fill the gap, get the work done, so to speak, that any appointment would only be good up until
Where is the language in the Constitution that says that?
That's why we argue, Your Honor, that you have to read Section 7 in conjunction with Section 8. We do this all the time in looking at statutes. You can't take one section of the statute and read it in isolation. So paramount is that judges shall be elected by the voters. The text, whenever there is a vacancy in the office, the governor shall appoint in the manner provided by law. Obviously, there's room for interpretation of that. A qualified person to fill the vacancy until a successor is elected and qualified. So we would argue, if you look at that whole sentence, that in this case, what it means is that the voters are allowed in this year, 2010, to elect the successor to Kathleen Blatz, and that the vacancy filler would serve only until January of 2011. And we do believe that that's faithful to the text of the Constitution. Overall, we agree with the reading of the amendment to Section 8 as articulated by the dissent in Winters versus Kiffmeyer. In other words, we believe strongly, and we think the precedent, particularly the amendment and the constitutional language, supports the interpretation that the language was never intended to allow appointment. The language that you see in this Section 8, as amended, was intended to ensure that the next election would occur. Now, that's a slightly different reading, we understand, from Dieter versus Carlson, but we do believe it's the appropriate reading, because otherwise the manipulation discussed in the Amdahl decision, the thwarting of election discussed in the Zettler decision can occur, and with all due respect to everyone involved in this justice system, has occurred, to the point where resignation after resignation occurs, appointment after appointment occurs, and certain seats, we selected the Chief Justice seat to make this argument, obviously, have no election year after year after year after year.
Counsel, what are we to do with the fact that the court in Deemer rejected that argument?
That's why we distinguished Dieter. In Dieter, they were not looking at the facts as we have them here. Two very important sets of facts here distinguish this case totally from Dieter. There is no precedent for what this court has before it on these exact facts. In this case, we are pointing out Kathleen Blatz was elected in the year 2000. She departed in 2006. That's when Section 8 kicked in. I mean, even if we give them that, petitioners are willing to give them that, okay, she departed in 2006 and the vacancy was filled by the governor. But it should have been run in 2008. And Dieter versus Carlson does not hold. And by the way, in the next election you can appoint again, and still there's no election. And in the next election you can appoint again, and there's still no election.
Counsel, doesn't the uniqueness of this situation undercut your argument that there's a systemic abuse?
We're the first ones to make the argument.
Oh, no, the uniqueness of this successive appointments.
The only point I'm making there, Your Honor, is that there is no precedent that would prevent this court from adopting our argument. It is not unique. We believe if you took a number of the seats around the state, you'd see the same problem. We're simply saying we're the first ones to come to this court in this type of position and make that argument, such that we don't have to be concerned that Dieter versus Carlson is precedent that would prevent the court from adopting.
Constitutional interpretation, does our constitutional interpretation hinge on the specific facts of each case?
There is no way to interpret the Constitution except through the facts of each individual case. I mean, I think we've seen that over time. Are there core precepts that the court can decide? Absolutely. And we believe the core precepts are printed right in Section 7. And, as I said earlier, Article 1, Section 1, which in the Minnesota Constitution states that government is instituted for the security, benefit, and protection of the people in whom all political power is inherent. So, can the court, do courts like this one decide core constitutional precepts? Yes. Do they use cases on their individual facts to make guideposts for further decisions? Yes. But in this case, petitioners believe they're the first ones to come make this precise argument, which, number one, shows the systemic overuse of the resignation and appointment process. Not just in the Chief Justice seat, but if you read Gregory Wurzel's affidavit, in a number of the seats for this court.
Counsel, first of all, is that I wouldn't in any way diminish or discount your argument whether this is the first unique set of facts or if, in fact, it's systemic. You're making the argument, and you surely have your right. That's how the law gets made. But what I am concerned about here is your statement that belief that this sequence is not unique, is systemic, and is whether you have any evidence, anything in the record, anything that shows this is other than a unique circumstance. I mean, it's important. I mean, that's a bold statement, and if it's going to be made, I just would need to have something that would back it up.
Thank you. I would point to the affidavit of Gregory Wursel, which is filed in this case, in which he has personal knowledge of having stated publicly that he was going to run for various seats as they were coming up for election on this court, and how each time he would state that there would be a resignation and an appointment. And that happened for a number of years, up to this year. Now, when we focus this year on the Chief Justice seat, in the record as well is the fact, undisputed, that Kathleen Blatz last ran for election in the year 2000, that she resigned in 2006, that there was an appointment in 2006, and no election. Then when the election was supposed to occur in 2008, you saw another resignation and another appointment, such that, again, in 2008 there was no election. Now it's 2010, and we saw another resignation from the seat of Chief Justice, and we believe very loudly proclaimed by the respondents the intent not to run this seat again. So those are things we can point to. I mean, the Historical Society records show the number of Court of Appeals judges who have been installed by election, which I believe I'm correct in stating is 0. And then in Clark versus Pawlenty, we came to oral argument with a chart showing the very, very few numbers of justices who have been elected since 1950. We believe all
you
those...
started your argument by saying that if we agreed with your definition of successor, there would not be discovery. If we disagreed with your definition of successor, is there discovery needed? And if so, what and why?
Thank you. Yes, there is. Number one, to gather in a way that we believe can only be gathered in discovery or through testimony, concrete evidence to support what we already have a lot of evidence to show, but to back up the notion that there's an overuse of the resignation and appointment. And even if you go back and look at the Attorney General opinion that the respondents have cited, the Attorney General back then said there's a difference between a retirement and a resignation, because obviously resignations can be picked, the timing can be picked. We believe we should have a right to discover whether there has been manipulation, which is the word used by the Amdahl Court, or whether there has been...
On this question of manipulation, is it your contention that vacancy in Article 6, Section 8 is limited to vacancies created by death or disability?
We have not taken that position.
But you're suggesting that the circumstances under which the vacancy is created may factually, in fact, you say it does make a difference.
It certainly can. It did to the Zettler Court. In other words...
When does it make a difference and when doesn't it make a difference? If Chief Justice Magnuson had been diagnosed with terminal cancer and retired, would you be here?
Well, first of all, those are the kinds of things that the voters think they should be allowed to discover.
Well, it's a fair question, though. I mean, because it goes right to the heart of what you think you need to discover. What factually makes a difference to what you want the court to hold?
Oh, let me answer it this way. We believe that the timing is important regardless of the reason for the resignation. In other words, we think we're entitled to discover why was the effective date of the resignation of Chief Justice Magnuson not May 10th, which would have put it 5 days before the filing period.
Would that matter in your view?
It very well may. That is to say, we don't have enough facts standing here today to be able to successfully argue it just on those facts. If, for example, there had been a conversation between Chief Justice Magnuson and, I don't know, Ritchie or Pawlenty, either one, about the timing of the resignation, we believe we're entitled to know that, to get those facts to make the argument. We don't know as we sit here today. All we have in the record with regard to what the governor has done is what the respondents have decided to give us. And if you...
I guess my question is, how do those facts assuming they are as you suggest they might be, how do they, I guess given the constitutional language, why are they necessary to our determination? Because the Constitution says whenever there is a vacancy. And that suggests, at least to me, that it doesn't much matter why there's a vacancy as to whether there is a vacancy or not.
Well, actually, I think that the second part of your question would be my answer. The Constitution says when there's a vacancy, but it doesn't
say when. It says whenever.
Correct. Whenever there's a vacancy. The question then would be, was there an attempt to thwart the election by the timing of the resignation? In other words, nowhere in the Constitution...
Assume that to be true. What does that tell us when the Constitution says whenever there is a vacancy in the office of judge, the governor shall appoint?
It tells us that there has been, it could tell us, that there has been an intentional, purposeful attempt to prevent an election by triggering the vacancy language. And that is what we have indicated. There's evidence being systemic. I mean, this is completely anecdotal, but you cannot be a lawyer in this state and walk the courthouses without hearing about judges who say, oh, they would never, ever let their seat go to election. Those are things the voters care about.
My question is, to the extent that the Constitution talks about whenever there is a vacancy, it would seem to have contemplated that.
I don't think so, or let me say it this way. Here's a different way of looking at it. It's a 6-year term. What other political office, elected office, do people resign continuously, time after time after time, before the end of their term?
Counsel, back to whether intent is necessary to our discussion. In Zettler, the judge appears to have timed his leaving office to avoid an election, and this Court said it doesn't matter what he intended. There's going to be an election. So how does intent figure into our deliberations here?
Well, that would be kind of the subset of our argument, Your Honor, would be that if this Court finds on these facts already in the record that there was sufficient showing of a manipulation under Amdahl or attempt to thwart the election under Zettler, then no, we don't need the discovery. But if in fact this Court would be thinking, well, we're not really sure that there's enough in the record to support what petitioners want to explore, that's when we believe we're entitled to discovery. In other words, if you look at the facts in this case, March 11, there's a resignation letter from Chief Justice Magnuson. March 12, and these are attached to the Robin affidavit with the respondent's submission. March 12, there's a letter from the governor to Mark Ritchie enclosing a copy of the March 11 letter. The final sentence is, this letter provides notification of a vacancy. Now, under the statute cited by the respondents, there is no vacancy yet until the effective date of the resignation, which is June 30. And yet already on March 12, we have notification of a vacancy. Now, interestingly, March 15, petitioners called the Secretary of State's office and asked for the official position. Are you going to post Chief Justice seat in the filing period? And the position already from the Secretary of State was no. Well, why would that be? And then you see Exhibit 4, March 31. It's not until March 31 that the governor accepts the resignation of Chief Justice Magnuson. How can we have a vacancy that removes an election from the ballot before there's even an acceptance of the resignation? Don't we have the right to ask the Secretary of State, what was that based on? And I would like to close this part, and I know I'm into my rebuttal time, but I'd like to wrap back around with regard to a couple of these questions. The timing, we believe, is important. How exactly it's important, we don't think we have sufficient facts to...
Counsel, you're into your rebuttal time, just so you're aware of that.
I am aware of that. Thank you, Your Honor. I just wanted to say this last thing. I think petitioners are entitled to ask these questions. Why was the resignation not effective May 10? And if it had been effective May 10, would the Secretary of State have placed this position on the ballot? And if not, why not? Why was it not effective January of 2010? Getting back, Justice Meyer, to your question about, what if it was a cancer or something? Well, what if it was a cancer where he could have served 6 years? I mean, why couldn't the work still get done after the commitment was made by accepting the appointment to the office? Why couldn't the departing person have gotten the work done? We still post it for election, and we still fill and succeed Kathleen Blatz by the selection of the voters. All those questions seem to us to be fair questions in the development of a record. Thank you.
And so you'll have 13 minutes for rebuttal.
May it please the Court, my name is Alan Gilbert, and I represent the respondents in this matter. What I'd like to do is bring the Court back to the core legal principles that govern the disposition of this particular case. And the Court has already referred to them, but I think it's important to focus on these principles. And I think it's clear that these principles establish, as we've indicated in our memorandum, that the Governor not only is permitted, but is obligated under the Minnesota Constitution to fill the vacancy in the office of Chief Justice. And of course, at the core of the legal analysis is the constitutional provision that Ms. Clark has referred to and the Court has referred to as well. And that's Article 6, Section 8 of the Minnesota Constitution. It's entitled Vacancy, and it reads as follows. Whenever, without qualification, whenever there is a vacancy in the office of judge, the Governor shall appoint in the manner provided by law a qualified person to fill the vacancy until a successor is elected and qualified. And the second sentence is equally important. It says the successor shall be elected for a 6-year term at the next general election occurring more than 1 year after the appointment. And of course, that change was made in 1956 to the Minnesota Constitution for very good public policy reasons, which this Court has referred to in various cases, which I will refer to as well.
Counsel, doesn't that raise the question as to what is being or who is being referred to with the reference to successor?
Well, Your Honor, even if there is an ambiguity, which we don't think there is, because of the case law that's already been decided, including Deemer in the state that you've referred to, if you accepted Ms. Clark's argument, then you wouldn't have an appointment. You wouldn't have someone to fill the vacancy for that year. And that was a clear purpose in 1956 to the amendment of the Constitution. You've referred to it in the Winters case, Your Honor, and I know Justice Anderson disagreed a little bit in terms of whether it's from the date of the appointment or the date of the when the judge takes the office. But without it, that purpose wouldn't be served. The voters of the state would not have the opportunity, as was reflected in the Amdahl case and the comments to the Constitutional Committee, that the voters should have the opportunity to actually observe the appointee in office before the next election takes place. So when you read those two together, they make perfect sense. And if you read it the way Ms. Clark is suggesting, you read out the second sentence.
Mr. Gilbert, is it necessary that you would end up with a gap? As I understand it, you contend that the language of Article 6, Section 8 mandates that the Governor would appoint someone to fill Chief Justice Magnuson's vacancy. But it wouldn't be mandated that the person who was appointed would necessarily then stand for election 1 year later. Would it not be possible that the governor could appoint someone who would run that the governor could, if he wanted, to appoint someone this year only to serve the last 6 months that would fill that gap, and then also allow the position to be open for election. Wouldn't that fulfill both of the prongs that are valued in Zettler as the importance of election and also providing continuity for any potential gap?
It would provide continuity, but it's contrary to the express language of the Constitution.
And how would you say that it's contrary to the express
Because it says that the election shall take place no sooner than 1 year after that appointment is made.
And you read that appointment to relate back only to the last vacancy filled?
Absolutely, Your Honor. Otherwise, you would have gaps in service. And under these circumstances...
What about the Persig case, when Justice Persig filled out a gap and then did not run for office?
Your Honor, those cases predated the 1956 amendment.
They do predate the 1956 amendment, but I'm not sure that on the language of the face of the amendment it would make a significant difference.
Well, it does if you accept the very purpose of the amendment, which was to allow the appointee to serve for at least a year before there is another election. And in the situation you're posing, Your Honor, that wouldn't happen. And that purpose, that reason for the significant amendment in 1956 wouldn't be realized. And that's why you have to read those two provisions together along with the purpose of that provision, which this Court has recognized in Winters most recently is a significant purpose that is served in allowing the voters to actually observe the appointee in action, so to speak.
But what about the Zettler case, where that would not have been the primacy that they were attempting to achieve there, where they did allow a person to run who hadn't auditioned for that position in a year? Are you saying that the right attaches to the person who's appointed to that position, or it's just a policy position?
It's both, actually, Your Honor, because the Constitution says the person who is appointed has that right. Now, Zettler was a little different situation, and the Court determined that in practical effect there was no vacancy because there would have been no significant gap in judicial service. And that's the judicial gloss that has been placed on it. At the same time, though, the Court in Zettler, as you know, recognized that in Deemer there was a 4-month gap. And that did provide a significant gap in service, and therefore there is a vacancy that is recognized by this constitutional provision, and as a result, as the Deemer Court held, the governor had a mandatory obligation to appoint. So the issue really is here, is there a significant gap in judicial service? And in this case, in contrast to Deemer, and certainly in contrast to the 2 days in Zettler, we have a 6-month vacancy. And that vacancy is not in the district court position. It's in the only Chief Justice position that we have in this state. And this Court is uniquely qualified to determine whether a 6-month gap in the Chief Justice position of the state of Minnesota presents a significant gap in judicial services. And that's the test. That's what Deemer says. That's what Zettler says. And in Winter, as I indicated, and I think Winter is significant, because in that case, Justice Page, in that opinion you authored, you recognize, as did the rest of the Court, the significance of the 1956 amendment to make sure that the voters have the opportunity to observe the appointee in action before there's another election. Now, Ms. Clark suggests, well, have you ever heard of a situation like this in any other office where you have a vacancy? Well, maybe you don't. But the point is, have you ever heard of any other provision for elective office that says the successor shall be elected for a 6-year term at the next general election occurring more than 1 year after the appointment? And if you look at all of the cases that this Court has decided in terms of judicial elections versus other elections, that there are some subtle differences. And that subtle difference was reflected in the 1956 amendment. It said in light of the unique aspect of judicial elections in some respects, that it is important and prudent for there to be that 1 year of service, at least 1 year of service, before the appointee's position is up for election. And I want to point out, too, as well, there's been mention of, well, in the Chief Justice position hasn't been up for election.
Counsel, can I just pause there, and I want to focus on this. I mean, when you have a state legislator's position vacant, they don't have the same language.
They don't.
And so this language is particular to the judiciary in filling vacancies.
Absolutely.
And so, and the language I refer to is that it's the next general election occurring more than 1 year after appointment. So you've got at least 1 year. Could have.
Correct.
It could have a couple of years
yes.
in there. And so that since this language is unique to the judiciary, I want you to focus on what is the particular purpose of this 1 year or more gap in the language that's in the Constitution.
Yes. Yes, Your Honor, and that's what I was referring to. The purpose, this language was put in the Constitution in 1956. And the Amdahl case makes very clear, the Peterson case makes very clear, the Winters case makes very clear. A major reason for it was to ensure that the voters can actually observe the appointee in action for at least 1 year before they have to vote for that position. Now, that is unlike any other office, including legislative office.
Now that would seem to imply that the successor, or the person who is appointed to fill the vacancy, is not prohibited from seeking to be the successor.
Precisely, and that's, of course, what the court said in Clark 1.
Okay.
But what I also want to mention, that I think it says too much when Ms. Clark says that in terms of the Chief Justice position, there hasn't been an election for a while. If you look at this provision and the purpose of it, I think it implicitly recognizes that it goes both ways, that you're going to have some positions where you're going to have an election sooner than 6 years, depending upon whether you have vacancies in a particular order. And Justice Meyer's position is a perfect example of it. She took over the seat from Justice Lancaster in 2000. And Justice Lancaster had been elected in that year, I believe. And it was 2002. But when you took over the position, then you had to be elected in 2004. There had been an election for Judge Lancaster's position in 2000. So the gap in that election sequence was only 4 years. So it works both ways. And the crafters of the Constitution and this amendment had to know that. They don't have to be a mathematician to figure that out. There are different vagaries of resignation and retirement. Judges, for whatever reason, are retiring or resigning. And it just happens sometimes that an election might go a little bit longer than 6 years. In some cases, as in Justice Meyer's situation, it might go less. So we shouldn't read into that something untoward. But in terms of the discovery issue, if you'd like me to address that, Your Honor.
Well, before you go on to that, I'm trying to look at, is that Article 6, Section 8, which really is, the Constitution is our template. Yes. The last two words of that article are the appointment. And the fact that appointment is preceded by the word the, it means it has an antecedent, which should be in this section. So is the antecedent there, the governor shall appoint?
Yes.
So, it'll be the appoint is the governor's appointment, and then that brings me back to the word whenever.
Yes.
And are there any constraints or bookends on the word whenever? I mean, does that mean any time, every time there's a vacancy? I mean, how are we to interpret that whenever, when followed by there is a vacancy?
Well, I think the plain language doesn't have exception, frankly, to the word whenever. There is some judicial gloss that's been placed on it in the Zettler case. In the Zettler case, the court has said that a vacancy has to be a vacancy in the sense that there's a significant gap in judicial service. And if there's any exception, that's the only one that's reflected in the Zettler case.
So it's not a complete absolute. In Zettler, we said there has to be some significant time.
That's what the Zettler case says, Your Honor. So that would be the only exception to it. Again, by judicial gloss reflected in that case. In terms of discovery,
Mr. Gilbert, before you go there, could I ask one last question on the earlier issue that has to do with the Amdahl case? In that opinion, and also in the Attorney General's opinion, which you've appended to your memorandum brief, it indicates concern over the possibility of a literal approach to constitutional interpretation that could give rise to manipulation. And Ms. Clark has referred to that possibility in this case because of the 12 years that we would be able to project that there would not be an election for the Chief Justice. Is this one of those circumstances that was envisioned in the Amdahl case or in that Attorney General's opinion?
No, not at all, Your Honor. In fact, Amdahl was really mentioning the 1956, I shouldn't say mention it, it was a significant part of the opinion, was referring to a problem that occurs principally between the primary and the general election when a candidate that wins the primary for some reason vacates the position after that.
And I understand that one as well, but it seems to me that they were referring to both circumstances where you could also have a repetitive office vacancy filler who could return without election over a period of time.
You know, that concern was reflected, Your Honor, but it's, again, it's not relevant to the proper interpretation of this constitutional provision.
So you would say there would never be a point at which successive repetitions of a vacancy filler being in office would cause concern over that?
Well, Your Honor, we're certainly not at that point with this case, and we're dealing with this particular case. And if there's 100 successive resignations, perhaps at some point someone might be able to create an argument of some kind, but the Constitution doesn't contemplate that. What we're talking about is, in terms of this motive issue, an individual judge or justice, for whatever reason, might resign or might decide to resign at a particular date. And for us to inquire into that is not in any way authorized by the Constitution. The Constitution, again, says whenever there is a vacancy. And I suggest to you, what happens if that was the principle of law? How would the governor or the Secretary of State ever know when they should appoint? Would they have to interrogate the resigning judge to make sure that their motives were not untoward based upon some standard we haven't even thought about yet? And not only that, Ms. Clark talks about she wants to do limited discovery for this purpose, but if motives were relevant or the reason for the resignation were relevant, where would the discovery ever stop? If the resigning judge talked to their court personnel or other judges about why they're resigning and when, then those people would be potential witnesses. And the court never contemplated that. And I would refer you to the Zettler case for that proposition, because in Zettler, the court talked about this, used the word thwart, which Ms. Clark refers to today as well as in her brief. And in that case, what Chief Justice Blatz said in her opinion is on page 851, 649 Northwest 2nd, 851. She said, we conclude that whereas, as here, the effective date of a judge's retirement would thwart an otherwise possible election, that would leave no significant gap in service. Use of the election process in the Constitution is required. But again, she very carefully didn't say if the judge is trying to thwart the election process. She said if the effective date of a judge's retirement would thwart the process. I would submit to you she thought ahead on this issue. She did not take the position, and the majority of the court did not take the position, that whatever the motives are relevant. Otherwise, why would she say if the effective date of the judge's retirement would thwart? So I would submit to you this issue has already been considered, and the practical aspect of it has been considered. And the parade of horribles, frankly, first of all, it's not relevant. But if it was, it would result in a ridiculous situation where the Secretary of State and the Governor would have no idea whether they could appoint, as the Constitution contemplates, and it would result in ridiculous discovery, potentially.
Counsel, I have one further question on that, along that line, and it's more of a mechanical question, but assuming your position prevails, based on 35101, Chief Justice Magnuson's resignation is not effective until June 30th of this year. So there's no vacancy that would allow Governor Pawlenty to make an appointment under Section 8 until that time. But as we know, candidates for the office are required to file their petitions before then. Without a vacancy or an appointment having taken effect, on what authority is it that the Secretary of State could decide not to accept petitions for candidacy during that time period?
Your Honor, it would be 35102. I'm sure you have it in front of you. You have 35101.
I do have it in front of me, but I don't think it quite gets me there. I know that 49126 has been referred to, and that provides for the Governor to give the Secretary of State notice on a judge's retirement, but it doesn't seem to encompass resignation. And I don't know if you're relying on that or
I am in part, and let me explain, Your Honor. 35102, if you have it, it stands alone from 35101. It says every office shall become vacant on the happening of either of the following events before the expiration of the term of such office. And then paren 2 says the incumbent's resignation. Justice Magnuson has resigned. It is effective, you're right, June 30th, but he has resigned. This language that is now in existing state law was in the territorial laws of the state of Minnesota back in 1851. This has been the provision that appointing authorities have used to appoint people to vacancies, because throughout the existence of the state of Minnesota, and even before it existed, through the territorial laws. And, Your Honor, it's important to recognize in that context that there is case law in this state that allows an appointing authority to appoint at this point in time, as soon as they know that someone is resigning, to appoint for a future date.
That's 35101.
Well, 35101 says that a resigning person can set a future date. I'm referring to the governor's authority, Your Honor, to appoint in the future. And that is found in the 1896 case of Childs. It's the site is 64 Minnesota 207 at page 210, 66 Northwest 264 at page 265. And this is what it says. It is the general rule that a prospective appointment to fill a vacancy sure to occur in public office made by an officer who, or a body which, as then construed, is empowered to fill the vacancy when it arises, is, in the absence of law forbidding it, a valid appointment and vests title to the office in the appointee.
So it's a theory that would then recognize futility, but does it provide for unforeseen circumstances adequately? If something should happen unforeseen that would then create additional problems in the appointment side?
Well, I'm not sure what additional problems you're referring to, but it contemplates the filling of any vacancy for any reason.
Counsel,
and, Your Honor, just if I could follow up, I want to be really clear. This distinction between retirement, you referred to Chapter 490, and resignation, I think you can read the two together. And, of course, a principle of statutory construction is that you try to reconcile two provisions. It would be an absurd result, and contrary to 645.17, Your Honor, if you said there's a vacancy only if you retire, but not if you resign. Because retirements are virtually always at a future date as well. So you have the same principles at stake. So even based upon statutory construction, we get to that result.
Well, that was my question. Is there a distinction to be made between the two?
Your Honor.
And if there is, what is it?
Your Honor, this Court in the Amundsen case that I know you're familiar with had to decide whether a judge who resigned and did not technically retire had retired judge status. And in that case, this Court said, you know, they're virtually the same. And the Court went through the different provisions that deal with retirement. The difference with retirement, which is not relevant to the substance of the issue we're talking about, as far as I'm concerned. The thing with retirement is some judges, as you well know, have retirement benefits after they've served for at least 5 years. In the case of Justice Magnuson, he hasn't served 5 years. So he technically was not able to retire. But under Chapter 490, if you're able to retire and the governor issues the order of retirement, then you're entitled to certain retirement benefits. Justice Magnuson's not, and that's why his is referred to as a resignation. But if you look at the Amundsen case, a 2006 case of this Court, although the Court went through the different subtleties of the retirement law, in point of fact, it said resignation and retirement virtually the same thing. Your Honor, I see that my time is almost up. I just wanted to, I don't know if you care to hear about this Georgia case that was cited to by Ms. Clark in her reply brief, which we haven't had an opportunity to refer to. But I don't know if she's relying on that case for the proposition that discovery is appropriate, but I wanted to cover it just in case that she is. That case did allow discovery. But the issue in that case was whether Georgia law required a special election in that case. And the issue was, did the justice in question resign before or after he had been elected to his position? And in that case, the justice had run for election, he won the election, and then shortly thereafter he resigned. Under Georgia law, unlike our law, but under Georgia law, if a judge or a justice resigns between the time of that election and the time that his term commences, then a special election is required under Georgia state law.
Thank you, Counselor. Your time has expired.
Okay. Thank you.
I wanted to follow up on a couple of points made by my esteemed colleague and also a couple of the questions from the bench. Petitioners believe that it is intellectually dishonest to claim that the reason for the vacancy is to fill the gap in service if the intent is to keep that person in office for up to 1.5 years after the election period. In other words, if the purpose, which we do not see in the language of Section 8, but if the purpose is to get the work done, then we do not need to appoint a person who delays the election. There's simply no connection in those two.
Except that the Constitution says there won't be an election until 1 year after that person is appointed.
Only if you accept the respondent's view of successor, the respondent's view of vacancy, and the respondent's view of the appointment. And piggybacking on the comment from Mr. Gilbert that in statutory construction you have to read both sections to make sense, we could not agree more. We have to read Section 7 to make sense with Section 8. And certainly one way of looking at it is that the judicial term shall be for 6 years. And when a judge takes the oath of office and promises the people of the state of Minnesota that he or she will serve for 6 years, the voters expect them to serve for 6 years. And that there is no, quote, vacancy if, in fact, because the judge decides for his or her own reasons, which could be personal reasons, could be other reasons, that they are not going to fulfill their oath to serve 6 years, then there, in fact, is no vacancy. That would be consistent with the Zettler reading. But the other point I want to make is that if, in fact, we start to carve wiggle room in the concept of the first word in Section 8, whenever, if we start to carve wiggle room in that with Zettler and say, well, there's no vacancy if, in fact, the judge his term was about to end in 2 days, then you see why discovery is necessary, because we cannot read the Constitution to give the departing judge the ability to not let the people have an election. And if it's read the way the respondents want it to be read, that's what's going on. And we believe that's what Amdahl was talking about, and that's what Zettler was talking about. And although not precisely the context, it is somewhat similar to the chief mischief that was discussed in the dissent in Winters. So play this out. If, in fact, respondents are saying, well, a 6-month gap is a significant gap, therefore there's a vacancy, that makes it all more relevant. Why is there a 6-month gap? And why could the person who took the oath of office to serve the people of the state of Minnesota not serve in such a way as to allow an election? And that is a relevant issue for discovery.
Who would be the judge of what reason is adequate?
I think that's unexplored territory, but I would answer it this way, that unless, and I think it should be a high burden, unless there is some terrific reason why the 6-year term could not be served, then there is no vacancy. Certainly the reason...
Counsel, when you say that, does that put your emphasis, I think you used the words in your brief, involuntary or unplanned, that's the type of vacancy that you're referring to. It has to be that type of vacancy.
Yes. In other words, and we see this in legislative office. You can see a resignation because, the death of a child, or, things happen. We understand that. It's not that we're not human. But it's surely...
Now, Counsel, I'm going to focus in what gives me a little problem with that definition is that as the term vacancy appears in a number of places in the Constitution. And the presumption is that the term vacancy will be used consistently in that document unless there's some indication otherwise. And where you would read that restriction on vacancy to involuntary, unplanned, would have, would you agree, collateral consequences on appointment of representatives and senators, vacancies in the office of Secretary of State, Auditor, Attorney General, or even with respect to the office of Governor, and how you would have the Lieutenant Governor. And so if you're going to, and this, I won't say you're adding, but if you're going to put that kind of a bookend and restriction on vacancy, don't we have to be aware of the collateral consequences of that definition on other provisions in the Constitution?
It's a fair question, Your Honor, and we have looked at those other provisions. And I think that the Court needs to decide, is the judicial vacancy language different or the same as, in its core principles, the other vacancy provisions in the Constitution? Because if you look at Article 5, Section 3, there is some similar language. The term is the person who had vacated the office, but the similar language to Section 8 is until a successor is chosen and qualified.
Counsel, to read, the problem I'm having is that to read Article 6, Section 8 the way you would like us to requires us to read out the word whenever.
I think there's a number of
how
words.
do we do that?
I don't think necessarily think that's one way of doing it. But I think that the word vacancy could also be defined. And we would argue that a vacancy by resignation is not a vacancy. In other words, deciding to resign early, particularly deciding to resign early so that the governor can appoint, that would not create a, quote, vacancy. That a retirement would create a vacancy because that's immutable. You can't help that. Now, and this is what I was getting to in response to Justice Anderson's question, surely no one would argue that if the Secretary of State resigns midterm, that the governor can't appoint. Surely he can. But surely no one would argue that there will not be a Secretary of State elected at the next election. And so I think when you're looking at what's different and similar between the appointments of other elected offices to fill a vacancy and what's similar and what's different with the judiciary, and that's really what the court needs to decide. And we would ask that the court come down on the side of elections. Because
so I want to get back to this question of what's the definition of vacancy. And, there are at least 4 other places in the Constitution where the word vacancy is used. So just to be clear, you don't have any authority for this court to apply a different meaning to the term vacancy in Article 6, Section 8 than where that term appears in the other places in the Constitution.
I have not seen it discussed in exactly this way in any of the prior decisions of this court. But as Justice Anderson was asking earlier, isn't it true we have different language in Section 8 than we have in the other, quote, vacancy sections of the Constitution? And we do. And that's why I'm saying the court needs to decide then how different is different and how similar is similar. Because one way of looking at it is that surely if Mark Ritchie resigned tomorrow, there would be at the next general election an election of a new Secretary of State.
Ms. Clark, Mr. Gilbert referred to the amendment to the 1956 amendment to the Constitution. And in that Article 6, Section 8, prior to the amendment, said in case the office of any judge become vacant before the expiration of the regular term for which he was elected. And that was then changed to the language that we're focusing on here about whenever there is a vacancy in the office of judge. Do you attach any significance to the difference in that language or to the effect of that amendment?
What we don't see in the amendment is the language that I heard my esteemed colleague talking about, and that is that this notion that the voters get to observe a person in office. I don't see that in the language. And we the petitioners would read the amended language consistent with the dissent in Winters versus Kiffmeyer. And we do not find support for the majority in Winters versus Kiffmeyer for the notion that it's a trial period for the appointee. But even if it were, the trial period was for Justice Russell Anderson. The voters had the trial period, and to the extent that was even a possible interpretation, it's not an issue in this case. And what the amendment surely did not say was, we get to try out person A, which is Chief Justice Russell Anderson. And then wait, no election on him. Now we're trying out person B for a year plus. And wait, no election. Now we're going to try out person C, perhaps ad infinitum. We would argue that overall, you have to read it that way, or you get to the point which you alluded to earlier, Justice Lansing.
Counsel, I want to follow up on this whole discussion of vacancy and other parts of it. You are telling us that we have to look at the Article 6, Section 8 differently when we're looking at vacancy. Is that correct? And you said, I think you said the question is how different, but I just want to understand that you should say that we look at this section differently than the other provisions in the Constitution. Is that correct?
I'm saying you can get there either way. You can look at vacancy as being the same for other offices, in which case there will always be the next general election where we install the successor. And that the amendment language in Section 8, Article 6, was in fact intended to ensure that we would have the successor elected for 6 years at the next general election. We suggest that alternatively the court could read, this has got different language, the judiciary is different from the other branches of government, and therefore we make our decision for the judiciary based on how we read Section 8.
Now, but in that scenario, there would be no appointment. There would just be the gap, and we would just live with it.
Well, there would be
no person work till the end.
What we're suggesting is that it be read such that, we've suggested a couple of different ways to arrive at what we believe is the core of the Constitution.
Sure, but no vacancy means no appointment.
Well, yes.
Well, it means so you're saying the governor wouldn't have authority to appoint someone to serve from June 30th until July 4th, whatever the date
next January, that the governor doesn't have authority to make that appointment and the seat would remain unfilled.
If the suggestion that I was just making was adopted, that in fact, if there's a resignation prior to the end of 6 years, there's no vacancy, correct. That would have to be the reading of it. And then the question would be, then it would shift the focus back in a different direction. Then the question would be to the judicial officer, may I complete my sentence, Your Honor?
But you can see that if Chief Justice Magnuson died today, there would be a vacancy.
Well, we do think that there are things like that. That's completely involuntary. I mean, no one could help that. And, you know, I mean, obviously we don't want anything like that to happen. I hate to even use it as an example.
But who gets to decide if it's good enough, if it's serious enough, if it's involuntary enough? I mean, you know.
No, I think it's a fair question. I think that unfortunately now, as we see it, and we're in the trenches a lot in the trial courts, and we see a lot of judges resign. Unfortunately, now the focus appears to us to be, why would you ever let your seat go to election?
So you really can't answer the question.
I'm attempting to do that, Your Honor. It would put the folks back on, why are you resigning before the end of your 6-year term, which you told the people you'd fulfill? And so could there be a situation where some high hurdle is, gotten over? I mean, this is not unlike what we do in
obviously you agree that death is a vacancy.
I think that all depends on where you want to end up.
All right.
And this whole question of who decides and do we want us to go down this road, and my question for you is that, and these aren't things in the abstract, is U.S. Supreme Court Justice Sandra Day O'Connor left, and the reason stated is her husband is in stages of Alzheimer's and she has a certain amount of time to spend with him and care for him. I mean, do I want to decide that that's not a good reason, or I'm going to say, well, Justice O'Connor, in a year your husband won't know you, so that's not a good enough reason? Do we want to put a court in a position that it makes and renders judgments as to what is involuntary, unplanned in those type of circumstances? I suggest maybe we don't.
And I understand that. It's not necessarily the way that it has to be read, and we've suggested other ways to read it. But what we are suggesting is that currently there is no scrutiny as to why numerous judges are leaving office before the end of their 6-year term, which they promised to the people of the state of Minnesota, and that if you're looking for a way in Section 8, one of the ways in is the definition of vacancy.
Counsel, your time has expired.
Thank you.
Thank you, counsel. This matter will be taken into advisement and an opinion will be forthcoming. We are adjourned.